Let's get the facts straight when lodging a partner visa application in Australia. If you are a Filipino and you have already overstayed or had your previous visa cancelled or refused. Yes, that's right, even if you are currently overstaying or had your visa cancelled or refused. Now, usually for a Filipino partner visa application to be successfully lodged and then granted in Australia, the Filipino applicant must be married or in a de facto relationship with an Australian citizen, an Australian permanent resident, or an eligible New Zealand citizen. Hello, Mabuhay. I'm Jose Respall, a registered migration agent with offices based in Sydney, Australia, and in Makati City, Philippines. I wrote this book, Avoid the Migration Minefield. Safely migrate to Australia from the Philippines. So you have the opportunity to understand the importance of using the services of an experienced and reputable migration agent and avoid any public interest criteria 4020, that is any false and misleading information or bogus documents lodged to the Department of Immigration. Now, the Filipino applicant and their Australian partner must be in a genuine and ongoing relationship. They must live with their partner, or if you do not, any separation must be only temporary. Both parties must freely consent to the relationship. For married Filipino applicants, their marriage must be valid under Australian law. So, underage, polygamous, and currently same-sex marriages are not legal in Australia. However, same-sex couples can apply for this visa based on their de facto relationship. A de facto Filipino applicants usually must have existed for at least 12 months immediately before they apply for this visa, or if permissible, register their relationship with their particular state or territory, births, deaths, and marriages, if permissible. The expansion of the partner visa eligibility in Australia was allowed, and if the Filipino applicant did not hold a substantive visa and have had a visa refused or cancelled since their last entry into Australia, they will be subject to Section 48 of the Migration Act of 1958. Now, this section bars Filipino applicants from applying for another visa whilst in Australia, except for certain prescribed visa classes, for example, a protection visa or a bridging visa. However, as of the 14th of September 2009, they may be eligible to apply for a partner visa in Australia if you meet certain strict criteria. The 4 specific criteria that must be met by affected Filipino applicants in order to make a valid partner visa application in Australia if they have already overstayed their initial substantive visa or were refused or had their visa cancelled are: number 1, the Filipino applicant must not have had an earlier partner visa refused since they last entered Australia. Number 2, the Filipino applicant must not have had a visa refused or cancelled on character grounds under Section 501 of the Act. Number 3, the Filipino applicant must provide with their intended application a Form 40 SP, sponsorship for a partner to migrate to Australia, completed and signed by an Australian citizen, an Australian permanent resident, or eligible New Zealand citizen who declares that they are the applicant's spouse or de facto partner. And number 4, they must provide with their application 2 prescribed statutory declarations from Australian citizens, Australian permanent residents, or eligible New Zealand citizens, other than the statement from your partner, supporting the existence of your relationship with your Australian partner. These declarations must be made not more than 6 weeks before the day the partner visa application was made on those prescribed forms. Meeting these 4 strict criteria will simply enable you to lodge a valid application. You will also still be subject to all other eligibility requirements for the partner visa. Once you have made a valid application, you will be assessed against the legislative requirements in the same way as all partner visa applications who apply in Australia. So let's make sure you do qualify completely before you lodge the partner visa application. Now, here is the good news. Because the Filipino applicant lodged an onshore partner visa application whilst not on a substantive visa, they are still entitled to Medicare cover, but will need to apply for full-time work rights. This has further implications on the sponsor's capacity to maintain the applicant during the 12 to 15-month application process period. If the Filipino partner visa applicant can't secure work rights. This aspect of the application must be thoroughly discussed and understood by both the Filipino applicant and the Australian sponsor, and a strong and compelling application for work rights needs to be submitted to the Department of Immigration for it to be successful. So, for more information about lodging your onshore partner visa application with the Department of Immigration whilst you are overstaying or had your visa cancelled or refused by using our exclusive 5-step partner visa application process, then please log on to this website and go to the registration page. Send us your details so we can arrange to discuss your particular visa application process and get your lives back in order again. Thank you for watching this video, and I look forward in meeting with you soon. Mabuhay!